However, there are some situations where it's better to actually file the bankruptcy after the divorce. So what we're going to be going over this week are those kind of situations. The first advantage to filing the bankruptcy after divorce is sometimes you have a situation where, based on the household income when they're married, the household makes too much. This would force the couple into a Chapter 13. However, if you wait till after the bankruptcy, because you split the households, each individual can now qualify for a Chapter 7. So if both persons, let's say, makes $40,000 a year and there's no children, you're going to be in a Chapter 13. However, those same people after the divorce, living apart, making $40,000, they qualify for a Chapter 7. So in that kind of situation, you're actually better off waiting till after you're divorced. Another reason to wait and file the bankruptcy afterwards is if you're really in a bad situation where you want no other contact with this person, you get the divorce over sooner. Divorces can take 6, 9, even 12 months, sometimes longer if it's contentious. If you file the bankruptcy beforehand, that's going to delay that a minimum of 3 months, 4 months, possibly a couple of years. So by getting the divorce done first, you will be done having to deal with that ex-spouse. Another reason to file the bankruptcy after the divorce is you can end up with 2 sets of exemptions. What this means is you may both get a set of 703 exemptions. You both can exempt $25,000 of any stuff you want. You both can exempt $5,100, $5,200 towards any one vehicle. This may help if you both have a lot of personal assets. It will not help, however, on the 704 exemptions, unless you guys both live there. To take a 704 exemption, you both must be residing in the house. It's going to be a really difficult argument to make that you should be able to not count each other towards having a household together, but yet both being able to take the 704 exemption. So just keep that in mind if you're trying to do this to protect for a house. I think it's possible, but you're walking a really fine line, and I think it would be a difficult claim to get past a trustee and a judge. So for 703s, it's going to work. For the 704 house exemption, don't count on it working. Another reason to wait and file the bankruptcy afterward is quite often when there's a bankruptcy involved, people have moved around a lot. And for bankruptcy, you need to have lived where you currently reside to qualify for that state's exemptions for at least 2 years, unless you want to subject yourself to another test. So if you just moved to California and you've only lived here, let's say, a year and a half, and before that you lived in a state with a lot worse exemptions, you may want to do the divorce first, even though you're going to qualify just fine for the divorce living in California. But for the bankruptcy to use our exemptions, you need to have been here for 2 years. So in that kind of situation, you have to wait anyway. May as well get the divorce over. Another reason to wait and do the bankruptcy after the divorce, as opposed to before, is if you're going to have an issue with a spousal waiver. If only one of you wants to file and the other party is not going to give you the spousal waiver, well, if you're after your divorce, the spousal waiver is not an issue because you no longer have a spouse. So if the spousal waiver is an issue, you can just wait till you're divorced, and then you don't have to worry about it. There are some disadvantages to filing the bankruptcy after the divorce. The number one is cost. If you wait and file the bankruptcy after the divorce, well, now you're going to pay for 2 sets of bankruptcy costs. That means 2 sets of attorney fees, 2 sets of filing fees. Even if you go to the same attorney, it's still going to be 2 sets of attorney fees, 2 sets of filing fees, and I doubt the attorney would take representing both you and your ex, at this point, probably a louse of the spouse. Probably the largest disadvantage of filing a bankruptcy after the divorce is you will have your bankruptcy trustee looking at your divorce decree. The trustee can void any agreement within the last 4 years if he thinks what's called a fraudulent transfer is involved. Now, just because the word fraud involved doesn't mean you intentionally tried to take money or take property illegally or give it to one spouse over another. For various reasons in divorce cases, one person might end up with more of the assets than another. For example, in lieu of child support, in lieu of spousal support, maybe one person values some artwork sentimentally and one person really wants the house. There's a whole host of reasons why, on paper, the divorce agreement may not divide the assets equally, at least on a dollar value. However, in a bankruptcy court, the trustee is not going to look at the emotional value. The bankruptcy trustee is going to look at the dollar value. So while emotionally it may make sense to get rid of something and save yourself $20,000, $30,000 in assets, the trustee is going to look at that and will say, wait a second, you got an extra $30,000. What can actually happen then is the trustee can go in and take that money from you, or actually if it's transferred to your spouse, the trustee can go in and take that money from your spouse. Now you've just basically had your divorce decree invalidated. The trustee gets the funds or the property. And now you're going to have to probably end up back in divorce court because your divorce agreement is no longer valid. So if you do the bankruptcy after the divorce agreement, take care to make sure your divorce agreement divides things equally, and understand while love and sentimental does have a value in bankruptcy court for the purpose of a fraudulent transaction, your love does not have a value. So just be cognizant of that. So if you have questions about this or any other things about bankruptcy, please give me a call at 559-274-2868, and I'd be more than happy to talk to you about them. Thank you.